Yes. All right. Good afternoon. Welcome everyone to our first voting session of the session, our inaugural voting session. We have two lists here. One has a bunch of some of the bills that have been withdrawn. Yep, there you go. That's the right motion. And then we have another voting list number 2, which you should have on your desk, which has 13 bills. So for the first list, voting list number 1, I have a motion. We can take this all at the same time. So I have a motion to unfavorable, withdrawn for all bills for the entirety of the list. It's been properly seconded. Is everyone okay with that? Yes. Excellent. Okay. We will now move on to Josh. We're going to go with Senate Bill 11, which is Senator Sidnor.
So as drafted, Senate Bill 11 reduces the radius from 1/2 to 1/10 of a mile within which a school zone may be established and a speed monitoring system may be placed in the school zone. So you have an amendment in your packet that's number 513523/1. So this would change the bill to retain the half-mile radius and say that unless recommended by a traffic engineering study, a school zone must be adjacent to a school and no more than 500 feet from the school. Essentially, this codifies some of the guidance that the State Highway Administration uses on state roads under their jurisdiction. And also in your packet, I think there is a document that details some of that State Highway Administration guidance and explains SHA's guidance on what a proper traffic engineering study is. Though I'd just note there's nothing in statute that defines what a traffic engineering study is.
So to be clear, so this bill codifies what is policy for SHA for state highways, roads to right now. Most jurisdictions use this anyway, or no?
The testimony was that most jurisdictions, although Baltimore City does not.
And then, to change, to deviate from this, you have to have a traffic study.
Correct.
Okay. Senator Sidor, do you have anything to?
The introduction of this bill was strictly about making certain that with school zones and these school zone cameras, that we're making certain that our children are protected and the cameras are close to where those children are. So.
Senator Carter.
Thanks, Mr. Chair. Just first of all, I think it's a really good bill, probably a necessary bill, Senator Sidnor. And I think that I'm wondering if there are currently existing cameras that don't comply with this and might I don't think this would address that, but do you think that's something that needs to be addressed?
Sorry.
Thank you. I asked MML that question about their jurisdictions, their members that may not have cameras that are incompliant, that may be non-compliant. They were unable to pull that information together in the short. And again, I asked them this question yesterday, so it was a short amount of time they weren't able to pull that together. My experience certainly comes from being in Baltimore and seeing the way that they use their camera program. So honestly, I'm not certain. I do know that the prior iteration of the bill, when SHA came in and spoke with me, they said there was concern there would be a lot of cameras that might be affected. So that's why I then moved to the policy that they had, because I think there would be less cameras that would be caught up in less costs. So
Next year's bill would address that, right?
Thank you, Mr. Chairman. I'm just curious why we went, wasn't there something in the language that MDOT already used, which was 1,000 feet adjacent to a school?
500. This language comes straight from state highways.
That there was 1,000 feet, because initially we were talking about that they were being placed up to a half a mile away.
Right.
And I thought MDOT's letter said that the way it's currently written, that they can do 1,000 feet. I just remember that in the information file. And the reason I'm asking is, and while Josh is looking, is because, if we're looking at trying to keep the kids safe, which we're trying to do, and if somebody is traveling at, say, 50 miles per hour, they're covering 73, almost 74 feet per second.
Mhm.
So if you divide that down from the 500 feet, that means they could be at that rate of travel in 6.8 seconds, could be in the zone where the kids are in conflict with the traffic. And the average person takes 1.6 seconds to perceive a threat while they're driving and to react to that threat and engage the mechanics of their vehicle of that threat. So if we scrub that off, you're about 5 seconds from that. So there's a tight window there of 5 seconds. I mean, it's a lot while you're traveling. I get it. But if we're talking about the actual, where we're talking about the momentum of the vehicle and it's traveling, the rate of travel, the amount of the feet per second it's traveling, and trying to keep kids clear of that 5 seconds seems like a really tight window. So I just was thinking, like, I thought it said 1,000 feet. I mean, because that 500 feet is less than 1/10 of a mile. Because the 1/10 of a mile would be 528 feet even. But now we've got it down to 500, which is even narrower than what we talked about.
I know when I initially went to SHA's school zone camera page,
Yeah.
it said 500 feet.
Okay.
Again, but I mean, if it's this committee's wish to go 1,000, I think that's better than what some jurisdictions are doing.
I mean,
So
if the intent for me, because a lot of crosswalks aren't immediately adjacent to the school, they're actually like a block up or a slight, and that distance would be encompassed in that 1,000 feet, in my opinion. I'm just trying to make it to where it's user-friendly and reasonable to actually have enforceability within the confines of what is the most area directly around the school with the most foot traffic. I love the
Thank you.
bill.
I will, no, I will say, I'm just looking at the bottom of the page. It talks about length of a school zone. And it says a school zone adjacent to a school should not exceed 500 feet or distance appropriate sign spacing dictates approaching or beyond the school or the school activity.
That's fine. I'm agreeable. I'm just trying to find that middle ground where we're protecting the kids, keep it safe, but not being unreasonable that we're just making it a money grab either.
Yeah, thank you, Mr. Chairman. And thank you for the bill, Senator. With this new amendment, does that now changes, and I don't think MDOT or SHA took a opinion on it, but does that now change their perspective of the bill or concerns?
I had asked them whether or not they would, with the changes, whether they would submit a different letter. I hadn't heard back from them.
And I saw that Mako also, I think Mako had a letter.
They opposed the bill even as amended.
Got it. Okay, thank you.
Mhm.
I'm trying to keep up with the yeah, I'm sorry. I just like to make sure you're faster.
Could I ask anybody a question? This is all not mandatory, is that correct? It's not mandatory to do this? Okay, and I don't believe Harford County has a speed camera. Could be wrong about that, but I noted, and so I just need to understand this in the fiscal note. It says in jurisdictions that do not operate, this is page 4 of the fiscal. In jurisdictions that do not operate speed monitoring system in school zones, required signage for school zones may likewise need to be moved and enforcement procedures may need to change to comply with the smaller school zones permitted under the bill. So I'm a little confused about that analysis. If this, if Harford County doesn't have a speed monitoring system and the language is discretionary with the county.
So the way the current law is, you can designate a school zone and then on top of that, you can install a speed monitoring system. So Harford County and these other counties may have school zones, even if they're not actually operating speed cameras in them. So that's why it could still affect them.
And I noted somewhere that I think the fiscal note said local fiscal note could be significant. Did we,
Stop getting that money.
so, all right, thank you.
What's the will of the committee? There's been a motion for favorable, it's been seconded. All right, we're gonna go around the horseshoe. Vice Chair Wallstrike, oh, actually, hold on, I'm sorry. We have to adopt the amendments. It's been it's the first time this year to do it, so, all right, so. Move adoption of the amendments. It's been seconded. All right, the motion has been, it's favorable with amendment. It's been seconded. So we'll go with Vice Chair. Here. It's the amendment. You gotta write them down. Yeah. All right. Vice Chair Wallstriker,
Yes.
Senator Sidnor,
Yes.
Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden,
Aye.
Senator James. So, Senator Washington. Senator Washington is a yes. Senator McKay.
Yay.
Senator Carter.
Yes.
Yes. All right, Senate Bill 11 has been passed with amendment. No, we adopted the amendment, bill as amended. Yeah. All right. Next up is Senate Bill 18. Senator Westville. Jamie, go ahead.
Senate Bill 18 establishes a police retention work group to identify and examine issues and factors potentially contributing to the decline in police officer retention statewide. The Department of State Police must provide staff for the work group. Work group members may not receive compensation, but are entitled to reimbursement for expenses. The work group must report its findings and recommendations to the governor and General Assembly by December 30th, 2024. Bill takes effect July 1st, 2023 and terminates June 30th of 25.
Senator West, were there amendments to the bill?
Yes. And I don't know which ones the people have because these things keep coming in. So
Never mind.
first of all, the American Civil Liberties Union wants off of the bill. And the suggestion that we had a couple of days ago, which I think is a good one, is to substitute the NAACP for the ACLU. So
Oh, yeah, Senator, I had actually spoken with the lobbyist for the NAACP today. They said that they would be willing to be on the work group. Is that unanimous?
All right.
Thank you, Senator.
There's been excellent. There's been an amendment to add the NAACP, the statewide conference of the NAACP. They've been consulted. It's been seconded and it's adopted unanimously. Okay, great.
now I've got three other proposed amendments to forward over the
You wanna
transcript.
go through it first?
What? I'll defer to the senator. I was just gonna mention, and I think we might be talking about the same thing, Senator, is Mako and the chiefs and sheriffs had expressed desire to see local law enforcement on.
Yes. The MACO wants a representative of a police department for an urban county and a representative of a sheriff's department for a rural county where the sheriff serves as the primary county law enforcement agency. And then simultaneously, we got another request from the Maryland Municipal League for one representative of police department for an urban municipality and one representative police department for a rural municipality. I'm wondering if we really need to do both of those. Don't the police departments of the counties also have jurisdiction in the municipalities?
Different policing.
Different policing? The answer is no.
Having worked in all different fields, that's different entirely.
So I really wanted the bill to be relatively balanced. And if we had 4 representatives of police departments,
I'm okay with that.
that unbalances the bill.
Thank you. I have a thought. I think that this is an important issue to be discussed, but it's super important that there's a well-rounded, diverse group of people. Definitely, there should be representation from urban and rural, but I'm actually going to make another suggestion. I realize nobody testified about it, but I think that it should not be so heavily weighted, people in traditional established law enforcement. I mean, this is about law enforcement interacting with the public, and there's lots of issues that have happened over the last number of years that have affected people wanting to be police officers. So I'm going to suggest that maybe this isn't the right group, but maybe somebody from Law Enforcement Action Partnership or some entity, not just like NAACP, that really represents kind of the voice of the average citizen and something like that. Like,
Is to appoint 1 citizen representative. So to balance these extra policemen, we could let the governor appoint 3 citizen representatives. How's that sound?
but I'm just saying, like, I don't know if people that are currently active in law enforcement are the best people to say, oh, this is how you get more of us. I think there's other places to pull from to.
I'll yield to Senator Muse.
Now it's on. Okay. I think that's what my friend was saying just now. We want it balanced. We don't want the same people all the time with the same connections, pushing the same old people into these positions. How do you get a fresh perspective? Because there's a different perspective. The perspectives are different when you talk to just my neighbor and then a police officer. They have different perspectives. And if we're going to capture it all, we just want to make sure that the groups that we're talking about are not the same groups who push the same people.
Like, because honestly, Black police officers in Baltimore that I talk to have a whole different perspective than maybe officers out in Frederick. So I would say, should I recommend Vanguard or should I recommend LEAP?
Here's what I'm gonna recommend. This is a very important bill and an important issue. We're still very early in session. So, and there's some really good ideas that have just come out just now. Senator Washington, you want to speak? I'm gonna recommend we table the bill, put it back on next, we'll work on it. We'll engage more folks, get more ideas. And the sponsor seems amenable to that. So, Senator Washington.
Yeah, thank you, Mr. Chairman. I appreciate your indulgence and holding this bill so we can add more representation on it, because I think representation matters. For instance, I was going to say recruiters. There's a lot of recruiters that aren't listed there, that are in HR professionals, academic professionals, trainers. We're also not reviewing what the training policies, what's currently being offered to police officers isn't in here to review right now, or even like the training practices, or even looking at what is the burden from people even making it through from start to finish of a training, because you can recruit them, they can be in it, but then they drop out at a certain point because of a certain issue that might come up. So I think there's other things we can look at versus just what's on this paper too. So I'll be willing to work with Senator West on adding some of those too.
And I don't know if there's a way to make the distinction, but if we are going to get police officers and we're going to get, well, not just police officers, but other persons who are working in the industry, I really would like to get someone who's a former, because former, whether it's a police officer or whomever, it doesn't feel under the gun to say or do, but they do know how it operates. And many of them will just tell you, without any hesitation, what was it like? What is it that we're trying to change? If I don't know what it was like, I don't know if what I'm trying to change is needed, necessary at all, or if it makes it better or worse. So someone who would just tell, this is how we recruited. For example, one of the persons I talked to said to me, they always get cut off. They get up through everything. But when they reach the psychoanalysis person, that's when they will come up with anything. And we found out that it was just a weeding out process to ask someone certain questions. It's so subjective. And for the process to be whatever this person says, who will meet with you for 1 hour, give you your psych evaluation, whatever they say, that's it. And you have no way at all of ever fighting it. That's it. You're gone. Goodbye. Then we looked at who they were saying it to. It was a difference in terms of the demographics of who they were letting go based on some esoteric or some way out there notion that you could never defend anyway. So those are kinds of things I want to know from those who worked inside. What really was the deal? And I don't know what the wording of that is, but you figure it out.
Thank you, Mr. Chairman. This question is for the sponsor of the bill. Senator West, is it your intentions to collect data through this work group or actually come up with recommendations?
Excuse me, come up with recommendations. We've got a problem. We're so understaffed across the state. We need recommendations that will result in, if we adopt them, bringing us back up to snuff.
I understand that. I just yield the committee. If everybody is in this work group, getting people to come with some kind of consensus of what the recommendations are going to be is going to be very, very hard. So I'm not against it, but I'm also yielding what the original intent of the bill was to come up with recommendations.
I think it's a good idea to try to expand somewhat the work group, but keep it balanced so that it's not all one way or the other. And hopefully, Senator, through 2 years of conversation, and this is a 2-year work group, that people will largely come to a reasonable consensus. And if the recommendation ends up being divided, and I've been on work groups in the past, the juvenile justice work group last year did not come up with unanimous consensus recommendations. I'm happy to go with that.
So I'm trying my best to stay as quiet on this as I can, but I can only do so much. So Mr. Chairman, you're in the service, in the military. This is a police retention work group. This is not evaluating the performance of police. This is evaluating how to hire and how to retain. If we're a military service member, who is best to figure out ways to how to recruit and retain military like-minded personnel? You got to have people that are in the service industry or the industry that you're talking about, the field you're talking about, are going to be the problem solvers, because what nobody's talking about here is that policing has changed exponentially in the past, especially 25 years, but a lot in the past 8 years. Body worn cameras, policing itself is not different. What is different is every moment of a police officer's interactions are now on video. Were there mistakes made 25 and 50 years ago? Yes, there were. Was there someone there recording it? No, they were not. The accountability is important, and there's no one that wants to hold police officers more accountable than other cops, because it makes my life miserable. It makes my kids' life miserable. This is about retention and recruitment. And Maryland has a problem. And the members that you're actually talking about appointing here voted to expose a lot of their employment factors, because unlike anybody else here, when a police officer makes a mistake, we're all human, you're going to make mistakes. It's now available for the public to get and put out on the internet or do whatever, because there's no limitations what they can do with it. So my question is, why would you want to go in that field? I tell everybody this day, why would you want to be a police officer? I've been a police officer 28 years. I wouldn't do it today if I was coming into it, because the potential for me to make it to retirement is minimal because of the scrutiny and everything that's happening. If you want to retain police officers, you need to have an open think tank environment. And I agree with having people that are coming in with differing perspectives, HR personnel and things of that like for recruitment ideas. But the reality is, this is a police-minded responsibility of people that have to get like-minded people to buy into an idea that The nobility is still there, and standing up and being protectors of the community is still admirable, not villainized, because it's only been villainized in the past 3 years. So I'll leave it at that.
No, I got you. I mean, I think that's, I mean, one word that I've heard Senator West use several times today was balance, balance, balance. And I think we have a balanced approach to this with obvious community policing is something that the entire community, we're all stakeholders. And so you've got to have that balance, and people that are invested in this need to be at that table too. So, all right, we're gonna hold this bill. We'll work, folks will get their ideas together and we'll work it through and we'll put it back on the voting list. So Senator West, you seem to be amenable to that. All right, excellent. Now, are we ready for so I want to make sure that our council has an opportunity to come up and then get back to your normal regimen. So if you'd like to come on up, do you want to do the primer first and then? Sure. Okay.
148.
This is Senate Bill 148.
So let me just pull this up. Thank you, Mr. Chairman. Senate Bill 148 requires the Governor's Office of Crime Prevention, Youth and Victim Services to help support programs providing services to victims of crime throughout the state. The bill also authorizes the office to award grants to public or private nonprofit organizations to operate the victim services programs. It requires money for the victim services programs to be provided in the annual state budget. And requires the governor in each fiscal year to include in the annual budget an appropriation that, together with the amount received under federal VOCA funds in the prior year, totals $60 million for the victim services programs funded under the bill. Executive Director of Governor's Office of Crime Prevention, Youth and Victim Services must annually report to the General Assembly on the victim services programs. JPR is secondary on this bill. Budget and Tax passed it and did have amendments, although I believe those were just sponsor amendments. We have with us Deneen Banks, who is counsel to the Budget and Taxation Committee.
So unless there's something he missed, you would like to expound upon, we give you the opportunity now.
I just know that there may have been a question in reference to public nonprofits versus private nonprofits. And I just wanted to explain a little bit what that issue was. So a public nonprofit could include the research institutions and the educational institutions, as well as medical facilities that receive government funding, versus a private nonprofit that would be a regular nonprofit that does not necessarily receive funding.
Senator Washington, sorry.
Yeah, just a quick question. What's the selection process of these nonprofits, or like where geographic selection criteria? Is there any weight to crimes that occur in certain jurisdictions where there's more victims in one area than another area? I just don't see that in here. If there is, maybe I'm missing it.
This is a GoCap. It's filtered through GoCap, right?
It is. Well,
This is-
the successor agency to GoCap.
Yeah. Well, sorry, yes, whatever the new name for children and what is it? It doesn't matter. The new GoCap. But do you have an idea of what their criteria are for the
I
redistribution?
do not know. It's supposed to be statewide, so it should cross all jurisdictions of the state. And then they have outlined which types of, on page 2 of the bill, who they need to consult with and collaborate with when making allocations from the fund.
Okay, sometimes, Mrs. Chairman, I see a lot of these types of funding bills, this seems like a really great one and I support it. But sometimes the funding is allocated towards one area versus another area and not necessarily where the need is. And so this is a lot of money, honestly, and I want to make sure that we cover the state and cover where the need is. And if that's already within the policies within GoCap, then I support it. I just wanted to know the answer to that. And I do have a structural question for it, since I'm new to this committee too, if you don't mind. Yeah, you mentioned there's amendments to the bill. Amendments is like sponsor amendments. Yeah, do we get those ahead of time, or is that like after, if it's amendment like that, or if, I mean,
No, so that means that they literally just added sponsors onto the bill.
no, I understand
Oh,
that, but just for all the other bills,
Yes,
like,
so
do we get those ahead of
It's a
time?
very good housekeeping matter.
Thank you.
So amendments need to be to council well ahead of voting. So what was the time frame we set for that? 48 hours? 24 hours. 24 hours before. And so the council has time to draft them and get them reviewed and everything. But then also amendments are not, they're still private until they're offered. And so because, senator could have an amendment drafted, but never, something could change and they never offer. So they're confidential until they're offered. So many times, unless the sponsor chooses to share them ahead of time, you won't see them.
Got it. Okay, makes sense.
Sorry,
Thanks.
go ahead, counsel.
Senator Washington, I wasn't sure if I was misreading your question on it. It was, I'd have to defer to Ms. Banks on which members of B and T were added on, but.
Process in which we receive amendments.
Okay, gotcha.
Here ahead of time.
Thank you, Mr. Chairman. In the past, with respect to sponsor amendments, typically at the time that we vote on a bill, we've been able to ask to be added on as a sponsor without having previously 24 hours earlier prepared an amendment. It would be, I think, a lot of work for council to be preparing all these sponsor amendments individually 24 hours in advance. So can't we just do the same thing we've done before?
No, so let me just do some cleaning. And I think if I'm getting this right. So sponsor amendments, two things. Sponsor amendments meaning like adding sponsors to a bill. That's easy. So that's something that can be done here right now. And so smaller amendments, small amendments, very simple amendments can be done here. But when they're complicated, it takes time. There's a review process and there's secondary and tertiary consequences to an amendment that you may not have thought through that need to be kind of fleshed out before. Mr. Chairman.
And Senator West, just to echo onto that, the non-substantive amendments, small amendments, actually, it is a huge time saver if the members don't seek a written amendment for the sponsor amendment. So those can get a little bit more complicated depending on the wording. But obviously, we're here to help and however the chairman wants to proceed with that. But as far as sponsor amendments, it's actually a bigger time saver just to do those by voice during the voting session.
Thank you very much. And I was actually the person who raised the question about the public or private nonprofit organizations. So, and what I was saying was generally when I see the term public and private, public is used for a public charity. Private is private foundation, but they're both C3s. So what I was wondering is by using the term in this manner, public or private nonprofit organizations, I'm assuming then that this money isn't necessarily limited to C3s.
It's my understanding from the bill that it is limited to the C3s, but there are currently some educational and medical institutions that already receive funding. For example, there is in the University of Baltimore receives funding for a program. The University of Maryland receives funding for a program, and Baltimore Washington Medical receives funding currently. So I think the intent is just to make sure that those types of organizations still are able to receive the funding.
All right, and those organizations I think would be public charities, right? They're 501c3 public charities.
They are, but they are also, the educational ones are also 501c3.
C3 public charities.
Right.
And what I was sharing with my colleagues was when you, again, with the term private, they usually tack that onto 501c3 foundations that aren't public where you can't get your your charitable contribution or the deduction. So I was just trying to be clear on how you all were using the words and making them understand. So I do appreciate your time.
Thank you.
So now I get it, like, cause they're like 501c4s that do like
Social welfare organization.
activism and
Right.
things like that. So you're saying you don't want the state money
Right. It's for
funding some sort of, I get it. Yeah. There you go. All right. Additional questions for council? Okay, there are no amendments that we need to adopt, are there?
No, you would be voting favorable as amended by budget and tax, assuming that there are no amendments that JPR wants to put on it. Although I caution that if you did, they would need to go back.
Yeah,
to-
yeah.
Correct.
All right. All right, Senator West, good.
Want to be added as co-sponsors of this bill. Is that possible?
I would suggest maybe prepare a floor amendment,
Okay.
just so we can get it out of committee, because if you do this, then you have to go back to that committee
Yeah.
and come back here, so.
Okay.
Okay, which I'm sure they'd be happy to do. All right, so the motion is favorable as amended. You can go through the horseshoe.
Senator Sidnor,
yes.
Senator West,
Yes.
Senator Muse,
Yes.
Senator Folden,
Aye.
Senator James,
Yes.
Senator Washington,
Yes. Yes.
Senator McKay, Senator Carter,
Yes.
Senator Smith.
Yes. Well, that's the most money we'll spend this year.
Anybody would like to be added to
No.
a sponsor amendment on this? Could you raise your hands and I'll just do one to include everybody? Is there anybody who doesn't want to be on a sponsor amendment? Okay, so I'll just put everybody on a sponsor amendment. Okay,
I can do that, Senator Wood.
what's that?
I can do that.
Could you do that? Great, thank you, Jamie.
Oh, we're gonna. That's coming soon.
Senator-
Yes, everyone's.
Yeah, everybody was.
Okay.
You're welcome. Thank you.
We're gonna go with Senate Bill 58, and we have Mr. Carlson here to assist with technical questions. Counsel for that is Josh, so Josh, go ahead.
Senate Bill 58 alters numerous miscellaneous provisions of the Corporations and Associations article, including those related to the issuance of stock or convertible securities as part of a conversion, stock certificates, scrip, and the limited liability company certificates issued in bearer form, remote participation at stockholders meetings, conversions of close corporations, directors of a non-stock corporation, dissolution of a real estate investment trust, and the Maryland Control Share Acquisition Act and statutory trusts, and makes other technical and clarifying changes.
This is, Mr. Chairman, this is the annual corrections bill for the State Bar Association's business law section. Each year they give us a bill similar to this. This bill is probably more technical than the bills we get in most years. And that's why we asked Bill Carlson to be with us. Frankly, I'm sorry, Mr. Carlson, you had to drive all the way down here. We would have been happy to take you by Zoom. But Mr. Carlson is here in case somebody does have a question about this before we vote on it.
Add other than my testimony back in January. If there are questions, I'm pleased to answer them.
Just a quick question. Could you remind on page 4, the sections 8 through 14, what a skip is? I don't recall.
Because nobody really knows what
Oh,
script is. So script is a kind of an arcane corporate document that's so rarely used. I think I've never done it in my 30-some years of practice. So if there were a stock split or something were to happen and you were to have a fractional share, so instead of 5 shares, maybe for some reason you had 5 and a 0.25 shares. A lot of corporations don't permit fractional shares. It's just too goofy. So they give you script. So you have this little piece of paper saying you have a right to 0.25 shares. So if you go around and find other people, eventually can get 1 share, then you come back to corporation and say, I want my share. It's a, you know, maybe in the 1800s it was popular. I think it's kind of an anachronism, but you know, we deal with it here.
Thank you very much. Thanks.
Okay, so you know, we often speak in shares of stock, and most corporations, even with the wonders of computers and whatever, prefer to have even number of shares. They don't want fractional shares. So if there was a conversion or a stock split or something that for whatever mathematical reason caused a stockholder to have a fractional share, you don't want to say to the person, well, tough luck. You give them what's called script, like a little piece of paper saying you now have a right to 0.25 shares. And if you can figure out how you can build yourself up to 1, you can turn in all these little pieces of script, you know, go to your friends who each have these little things and say, I want to share a stock. So it's kind of like an IOU type of thing in a way. I mean, it's probably not the exact term, but that's what it's equivalent to.
And just one other question, page 6, lines 20 through to 25, when you're talking about modifications, could you explain what the purpose of this particular?
This is the page on 520.
Right, 5202 non-stocks.
Right, and this is actually probably one of the most it's probably the most useful thing in this present bill. That may be missed upon people, but many nonprofits, many non-stock companies will have in their bylaws, and a lot of the non-stock companies, especially smaller ones, are doing things informally. They may not hire a lawyer, they may find something on the internet, and they'll say, the county executive is on our board, or the pastor of this church is on our board, or the CEO of some organization's on our board. And they'll just say, you know, so as a pastor retires, a new one comes in, or whatever scenario you want to give as an example, they think, oh, you know, she or he's on our board. Well, under Maryland law, you have to elect the person. Someone can't serve under present Maryland law because of their office. And what happens sometimes if there are later disputes, you know, the argument comes up, well, who is that person? They're the, you know, county executive. Well, so what? They were never elected. So you get into disputes about quorums and votes of meetings, and it has led to litigation. So it's a common practice that people don't realize they're doing incorrectly. So we want to make it easier that if an organization, a non-stock organization, it can't be a stockholder company, wants to do that, they're free to do that. And it's common, so recognize it.
Generally, I guess this would be for honorary board members that you're not looking.
No, I mean, it could be for that, but it could be someone that you want to be on your board. I mean, it's not unusual when you have, you might have a hospital that has a funding foundation, and you have all sorts of nonprofits and different examples where, you know, you want someone to automatically be on your board, and it's not unusual, but it would be more than honorary. I mean, it would be for any kind of director.
So it's like an ex officio?
Yeah. I mean, we purposely in this statute didn't use the word ex officio because that phrase is used by so many different people in so many different ways. To say ex officio among 10 lawyers, you probably get 10 answers what that means. So we just try to, just make it clear here. If you're serving because you are in a specified office, you will then can be on the director, the director on the board.
So then that individual, say me as senator for 44, once I vacate, whoever the senator 44 will remain without the necessity of having an election.
Correct, yes.
Gotcha. Okay, thank you.
All right, Josh, there are no amendments for this bill, so correct? Okay. What's your pleasure?
Second.
All right, there's been a motion for favorable. It's been seconded. We'll run it.
Senator Wallstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator
Yep.
Muse.
Yes.
Senator Folden.
Aye.
Senator James.
Yes.
Senator Washington.
Yes.
Senator McKay.
Yay.
Senator Carter.
Yes.
Chair Smith.
Yes. All right, the bill passes unanimously.
Thank you.
Thank you very much, Mr. Carlson. Thank you. So, sorry, yes.
To formally thank Bill Carlson for coming down, not only to the bill hearing, but also today.
No,
You're-
I'm happy to be here.
Yeah.
I'm also happy to hear the other things that go on here that which are more important. So I like the snapshot. Thank you.
All right, now we'll go back to the regular order of the list, and we'll go with Senate Bill 42, Senator Carter. Josh is counsel.
As drafted, Senate Bill 42 requires a court to set a hearing on a petition regarding a proposed relocation of a child of more than 40 miles away from the current residence on an expedited basis. The bill as drafted also prohibits a court from considering a child's time spent with a party who relocates in violation of certain statutory requirements to the advantage of that party in a subsequent custody hearing. So you don't have an amendment in your packet, but the sponsor wanted to introduce an amendment which I can describe orally. So if you turn to page 2 of the bill, starting in line 8, the amendment would strike beginning with the word of down to the word residence in line 9 and replace that language with that would significantly interfere with the other parent's ability to maintain the predetermined parenting time schedule. And then the amendment would also delete the new language being added in lines 24 through 26. So the entirety of the bill would be to require that if either party in the custody dispute files a petition regarding a proposed relocation that would significantly interfere with the other parent's ability to maintain the predetermined parenting time schedule, the court shall set an expedited hearing.
I'll just say I agree with the amendment. I discussed the matter both with with the MSBA, somebody from the judiciary, as well as the House sponsor. I agree that saying 40 miles was a very arbitrary term. I did testify about that at the bill hearing. And I think the new language is just better language. And I think we achieved the goal. So I'm happy with it.
No, I agree with the first part. I'm curious, what is this, when you strike 24 through 26, what was why was that done? Sorry, good. Josh or James, Josh or Senator Carter.
So I can just explain what was being struck. So that is, the court may not consider a child's time spent with a party who relocated in violation of this section to be advantageous to that party in a subsequent custody hearing. So basically, if you relocated the child in violation of certain notice provisions in the custody agreement, the court would not be allowed to say, you've spent more time with the child since the move, so therefore you have an advantage in the custody hearing. And that's being struck from the bill.
All right, so I'm gonna make a motion to adopt the amendment. It's been seconded. Okay, excellent. What's your pleasure? Sorry, good. Motion is for, motion's been favorable, motion for favorable as amended with the amendment. It's been seconded and we'll run it.
Senator Wallstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden.
Aye.
Senator James.
Yes.
Senator Washington.
Yes.
Senator McKay,
Yay.
Senator Carter,
Yes.
Chair Smith.
Yes. All right, the bill passes with the amendment unanimously. All right, we'll now move on to Senate Bill 54. Council is Jamie.
Senate Bill 54 repeals the crime of unnatural or perverted sexual practice under section 3-322 of the criminal law article. It also makes conforming and technical changes throughout the criminal law article due to the code, or excuse me, due to the repeal. And finally, prohibits the expungement of a conviction for unnatural or perverted sex practice as the offense existed prior to the bill's effective date of October 1st, 2023, under specified circumstances. There are no amendments.
All right, just for the record, though, in speaking with the State's Attorneys Association, can you just elaborate? Do they still use this tool, and what were some of the arguments as to why they do not?
So as a practical matter, in years past, we had received information from certain prosecutors just as far as how this was used. Some had indicated that it was previously used as a plea tool, either for reasons surrounding the victim's ability or willingness to testify at trial, had it gone to trial, or I suppose potentially, if there were weaknesses in the case. In any event, MSAA has advised that they no longer use this as that sort of mechanism.
Questions from the committee, discussion? This has been a bill of some debate in the past, so additional questions? No? There's been a motion for favorable and second. There are no amendments, that's right? Correct. Okay. Motion for favorable, it's been properly seconded. We'll run the bill.
Senator Wallstreicher,
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse,
Yes.
Senator Folden,
Aye.
Senator James,
Yes.
Senator Washington,
Yes.
Senator McKay,
Yay.
Senator Carter,
Yes.
Chair Smith.
Yes. All right, Senate Bill 54 passes unanimously. All right, we'll now move on. So Jamie, we'll stay with you with Senate Bill 69.
Senate Bill 69 requires the Maryland Police Training and Standards Commission to develop a uniform citizen positive community feedback process to be adopted and followed by each law enforcement agency. The process must be simple and posted on MPTSC's website and on the website of each law enforcement agency that maintains a website. Each law enforcement agency must maintain a record of positive community feedback for all law enforcement officers within the agency. A record of positive community feedback is not considered to be a personnel record under the Maryland Public Information Act. Notwithstanding any other provision of law, records of positive community feedback are subject to public inspection in accordance with PIA. Also, no amendments for this.
Discussion from the committee, Senator Carter.
Certainly. Mr. Chair, we talked about this bill before, and I'm going back to 2021 when we passed the Police Accountability Act. And I remember that there was an effort to put this into the bill. At that time, I didn't support that. And the reason is there is no problem with commendations from the public right now reaching police agencies or the public. Right now, I can't speak for every agency, and I understand this is an effort to make it standardized. But the reason that we had to dissect and recreate functional processes for police complaints to make sure that those complaints were legitimately investigated and legitimately determined, decisions determined, is because there was a recorded history throughout the state and many agencies of denying complaints and a recorded history of no transparency with that process. And so we needed to do that. But there is no testimony or no record of a recorded history of a problem with people being able to give police officers commendations or compliments. And I don't think that the intent of this is bad. I know that the senator believes in this. I've talked to him at length about it. He gets very happy when he talks about this bill because it makes him feel good as a lifelong law enforcement person. And I just feel, and not to be very hard-nosed, but to some extent, I believe that it's a feel-good measure, and it's in an effort to have an appearance of striking balance where there wasn't really a need to have balance because we were addressing a specific problem. This isn't fixing a problem because there isn't a problem to fix. There is no difficulty with people being able to write a letter of support or write a commendation to a police officer. In fact, I know most of the forms that I've seen for different civilian review boards and those kinds of things, investigatory bodies say complaint or commendation. That's what the forms already say. So there's not a problem with the public being able to do that. So my thought is the bill is not necessary. I understand that we want to appear to be balanced, but this isn't, to me, a situation where we need to do that.
No, I appreciate that. I mean, just for the record, this bill did pass unanimously from this committee last year. One excused, sorry, Senator Cassidy was excused. But for me, look, I think this is standardizing it and making sure that this is nested within the file. I see no problem with that. And I agree. I don't think it's going to change the game as there wasn't a balance of problems. And I think that you're absolutely right. One of the reasons why I was a huge proponent of Anton's law, which is why we made it a priority during our reform efforts to get it out, was because there was no access, and still continue to press on that because even in my county, the process has been frustrated by the county's charging exorbitant cost, just huge cost to get access to those files. So we still have work to do in that regard to get that access to that information that we fought hard to get to. So I understand that. But for me, ensuring that there's at least a standardized balance, I have no problem with standardizing that process.
But what's the problem that we're fixing?
Yeah, I think it's just standardized. I don't think I agree with you. I don't think there's a significant problem with.
Is there a difficulty with the public being able to get access to good things said about police officers?
No, I don't. I think, well, there's difficulty right now getting access to the personnel files, period. I'll put it that way, both good and bad information. But I think there's no problem with ensuring that the positive stuff is nested within that file as well.
I would just additionally say that there's been no public testimony. I mean, again, the legislation that we passed was the long overdue result of a long time public outcry for a need to make many, many changes in the institution of policing in Maryland. And we did some of those things well. We did some of those things probably not as great. Some things there's more to do. But I feel that this is an effort to create the impression that we somehow are being fair when we already have been being fair. We have never been unfair. This isn't a situation where we need to say, oh, we need the good and the bad. It's just not that kind of thing. And I think that there's a real need based on even talking about Senator West's bill, the retention, the morale is low, but the morale is low for a reason. And it's going to be up to the policing institutions to rebuild that. Not for us to say, we're going to assist with this public relations effort. I just think this is, in my mind, I don't want to be honest with you, I don't want to say what I think it is because I think it's it'll sound too harsh to too many people, but it is unnecessary. And I could see how people in the public, some people could find even the idea of doing this on the heels of what we've just done and not even completed to be an insult to the great need that we needed, that we tried to address with police accountability.
We'll go to Senator West. I just don't, I think you can hold both those ideas in your head at the same time, that you can both be accountable and strong.
It's like we have a protective order. And then when it's, then we say it because we have it because it's based on an allegation of abuse. So it's like, because there's a long history of abuse that's been unaddressed and inadequately addressed. So if you, it's like saying, okay, well, we allow people to file protective orders. Maybe we should allow people to file safe orders. Hey, I'm in a relationship and there is no need for protection. It's simply unnecessary.
So this deals with one's reputation in the world. And so because of, what was the name of the law we passed? Anton's Law. Because of Anton's Law, the press is able to get access to the personnel file, which apparently currently does not contain this positive kind of information. If somebody gained access to my personnel file for what, and all it has is negative stuff written about me and nothing positive that I've done, I would prefer when the article comes out, printed by or prepared by an honest reporter, and some are not, but most are. I would prefer to have them at their disposal, everything about me. And so they can say, yes, there's this bad information about him, but on the other hand, he's received this commendation, this award of excellence. So a balanced present, we keep using the word balance. A balanced presentation can be printed in the newspapers, and people who know me will see a balanced presentation about my reputation rather than just all the negative stuff.
Oh, the old proverb says, if it's not broken, don't fix it. I don't see what's broken. I was here in its origin when we worked on all of those laws from its infancy. This kind of sets it up in a way that says there's something not fair about this process. And I can see that, and knowing the intent, because again, we was here with that, I just don't see what we're fixing with it, and I'd rather not bother with it at all. So I'm not gonna.
Thank you, Mr. Chairman. Senator Muse, if it's not broke, don't fix it. But when a file that is shared with the world only has negative complaints, we've just created an unfair balance to paint the whole picture of that particular officer. So it seems like by what we've done with Anton's Law, which has got a lot of good stuff there, however, we're creating a picture where it's just negative for that particular officer's reputation. Nothing good sprinkled into it. So I kind of believe that.
Trying to figure out who decides what goes into the file. Is it as such that only negative? It's a problem now. Is it that only negative things can go into it? And sometimes we're assuming that there's no standard. Okay, gotcha.
So the problem is not that there is, thank you, Mr. Chairman. The problem is that there is not, I wasn't a proponent of this bill, by the way, when it first was brought up. I said this was probably not the best idea because it just was a feel-good measure, is I think exactly what I said. But after more and more thinking about it and hearing like the differing opinions of things, hearing the discussion we had earlier about the police retention work group, it does push one to believe that with the representation that we were looking at on the retention work group, you know, who better? I mean, that's a retention thing. Retention is important. We're not having that. We're losing bodies. Why are we losing bodies in law enforcement the past few years? Because of the extra scrutiny and beyond, honestly, because police officers have been vilified. I'm sure that your godson tells you the same thing, that it's a tough time. to retain and to be a police officer, right? To retain police officers, hire them and be one. So this bill, as I understand it, does not change anything. There's already the ability to put commendations in their file.
Right.
The problem is that it was an exclusionary part of the file as a part of Anton's law that they were not allowed to have access to, because it was hidden as not a part of their internal affairs file. So it was very specific that they were making it only available under these files. But these areas that were a personnel performance file were not available for release. So this allows the press or anybody else to say, yeah, we want his internal affairs file, but we also want to have access to his, the personnel file that's held by his supervisor that has his commendations that come up in an annual review.
Can they do that now without this law?
It is my understanding that that is not a part of what can be requested.
Do people request it? Well, let me just say this, and we know this, and Mr. Chairman, you may know that some members in the committee may know, we just had a couple of Fridays ago, we had a public forum about the fact that even 2 years after the passage of Anton's law, they're still most of these public records are supposed to be public are still being denied. This is a real issue. Last year, we created a task force. The task force has not met one single time, my understanding. And so my suggestion would be, why don't we let Anton's law actually work the way we intended before we go adding to the pot with something that is not likely necessary and really doesn't address the problem? And I guess my concern is that I don't actually agree with you. I think the perception, Senator, is that you're a part of law enforcement. I'm a lawyer, and oftentimes lawyers get bad raps and get talked about pretty badly. And even sometimes we get disciplined, I think sometimes even unfairly. But at the end of the day, we didn't do anything, or this body didn't do anything to vilify police officers. What we did is we tried to create accountability and transparency where there was a real need. And I think there's a lot of reasons why there's a retention problem and a morale problem, but it's got to be something that is addressed from the bottom up. It has to be something that's acknowledged in terms of there was a real problem here, and we're looking to clean it up, fix it up, and be accountable and transparent to the public across the board. It can't be just about bruised egos and low morale, because that occurred because people were getting harmed. So we can't just negate all of that because we're now at a problem of low morale. So my thought is, let's fix Anton's law. Let's make that work. And if we still think there's a need to do this, we come back and do that later. But frankly, even if I don't think we need to do this, but if we did, I'd suggest it at the very least, it's premature.
So no, you're sorry. Okay, we'll get to you in a second. So the task force that was created, you're the chair of. I think we made you the chair of that task force, and so the energy is there. You can get that lifted off whenever you want at your leisure.
Call this committee over the interim about the meeting, and there was no movement whatsoever. I wasn't given any type of so I don't think that's.
We'll make sure, call me, we'll make sure we get the energy going on that. So we'll go to Senator Folden, but before that, I say, look, like this if the personnel file is complete with all this information, it's about access to information. And all of the things that would be existing there would be true information that is not there now. When you make that request for the personnel file, and we actually get it when Anton's law starts actually working, if you are a reporter, you're going to use the information, the disciplinary information to build a case or to publish a case. You don't have to use everything in the file. They're going to be over-inclusive in getting the information, and they're going to use the information that they want to use to draft or craft whatever message that they want to craft. So, and that's why, again, at the beginning, when we were talking about this earlier, Senator Folden, look, I mean, the people that want to just publish the negative information are going to do that no matter if this information's in there or not. So, in a way, yes, I'm not sure how much of a difference it's going to make, but standardizing it and ensuring that the file is complete with positive information seems like a good idea to me. And that's why I'll be supporting the bill. But go ahead, Senator Folden.
Thank you, Mr. Chairman. Yeah, I mean, I agree with that mindset and that thought process. And I'm not sure what the holdups or what the angles are that are being utilized to not release information. But the idea that the statements of bruised egos is it's kind of funny to me that that's the angle that's taken in statement made, because the real bruised ego seems to be a lot of attorneys that are chasing things, trying to make their name made off of how that they are able to go and attack police. And part of this is that the vilification happens by those same attorneys asking for these files, trying to be disparaging of law enforcement. I'll leave that as its own issue. The other issue is that these files are being weaponized, and they're being weaponized and activated against law enforcement, and they're being put on the internet for anyone and everyone to see, with no responsibility by the person that posted to put a proper or a correct narrative. They're allowed to put whatever narrative they want on the files that they get. And when they do that, there are collateral effects, and those are the family members, the parents, the children of said police officer. So you want to talk about a morale issue? The morale issue isn't the good of wanting to do the job. The morale issue is because there's constant attacks and an unwillingness to immerse yourself in the trade that we are talking about. I encourage all of you, go on a ride along with your law enforcement officers, because I promise you, Baltimore City police problems are not Frederick police problems. They are wholly different because the style of policing is different. But we've made this law surrounded around, and we do it statewide for the purposes of legislating Baltimore's problems statewide instead of being accountable for those actions within those districts.
Okay.
Thank you.
Nice. All right. So I want to make a correction for the record. So the task force was passed. There was no chairperson appointed. I think the presiding officers have that responsibility. I will make sure that we get to that. So that was, and I know that Senator Carter inquired over the interim. I'll make sure we put energy into that. So I want to make sure that's on the record correct. So we'll get. Sorry.
You just said when a reporter wants to do something, I know a little bit about reporters. What they're going to print anyway. Nothing's going to change their mind from what the narrative is. So, okay. Well.
Thank you, Mr. Chair. The word transparent was brought up for not having this bill. That Anton's law was trying to be transparent. Well, by inserting this into the particular line, by passing this, you are actually being transparent, because you are giving both positive and negative feedback.
All right. Further discussion. There are no amendments, right? All right. And so there's a motion for a favorable. It's been seconded.
Vice Chair Wallstriker,
Yes.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Muse.
Pass.
Yes. Okay. Senator Folden,
Aye.
Senator James,
Yes.
Senator Washington,
No.
Senator McKay,
Yay.
Senator Carter,
No.
Chair Smith.
Yes. What's the final count?
And no.
And Senator Muse is no. Can you tell us the final count?
7-3.
So the bill passes 7-3. All right. That's a good discussion. Okay. We will now go on to Josh, Senate Bill 74.
Senate Bill 74 establishes that a conviction for specified drunk and drug driving offenses constitutes a prior conviction for purposes of determining subsequent offender penalties for a person unlawfully operating or attempting to operate a vessel under the influence of alcohol or drugs, and vice versa. The bill also establishes that a person convicted of specified drunk and drug driving offenses is subject to increased subsequent offender penalties if the person has previously been convicted of manslaughter by vehicle or vessel by gross negligence. Well, it doesn't also include manslaughter by vehicle by criminal negligence, although that has a lower penalty, so I think that's why it was left out of the bill.
So everyone understands? All right, any discussion? All right, no motion for favorable, it's been seconded.
Vice Chair Wall Striker.
Yes.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Muse,
Yeah.
Senator Folden,
Aye.
Senator James,
Yes.
Senator Washington,
Yes.
Senator McKay,
Yay.
Senator Carter,
Yes.
Chair Smith.
Yes. All right, we're gonna go to Senate Bill 99.
Senate Bill 99 increases from $10 to $30 the amount of the service charge that may be imposed by the circuit court or district court for a dishonored check. The reason given by the judiciary for the request is to allow for the central collections unit to be able to collect these service charges on these dishonored checks.
All right. Sure, Senator. So,
Favorable?
oh, yeah, second. All right. Motion. All right, motion has been for favorable, it's been seconded. We'll run it.
Senator Wall Striker,
Yes.
Senator Sidnor,
Yes.
Senator West,
Yes.
Yes.
Senator Muse,
Yes.
Senator Folden. He's not here.
Yes.
Senator James,
Yes.
Senator Washington,
Yes.
Senator McKay,
Yay.
Senator Carter,
Yes.
Chair Smith.
Go back to Senator Folden.
Which bill?
Senator Folden,
Which one? 99? No. Was that a fee increase?
Yeah.
No.
Chair Smith.
Yes. That's a good point. Okay, Senate Bill 99 passes 9-1. Okay, we'll now move on to Senate Bill 106. Shamari's counsel.
Senate Bill 106 is written exempts from execution on a money judgment without election by the debtor up to 500 in a deposit account. There is an amendment.
I know that there was some Senator Sidner, there were some forthcoming amendments. Do you want to hold this for a week or do you? Yeah, sorry, no worries.
The amendment that I put in, it was drafted erroneously, so if I could hold it, I would appreciate it. Thank you.
All right, so we're gonna hold Senate Bill 106. We'll get it on the next list, though. All right. Senate Bill 115 is Josh.
Senate Bill 115 establishes that the jurisdiction of the juvenile court is concurrent with a federal court sitting in the state over proceedings involving a violation of federal law committed by a child on a military installation if the federal court waives its exclusive jurisdiction and the violation of federal law is also a crime under state law. So, yeah, for instance, if you have a juvenile who's on a military installation and maybe they get into a fight, something like that, because it happened on a military installation, the federal government has jurisdiction over that. But their courts don't have the kinds of juvenile services that our courts have. So as long as the federal court agrees to waive jurisdiction and the act is also a crime under Maryland law, that child will be able to go into the juvenile court system here.
Vice Chair Wallstriker,
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden,
Aye.
Senator James,
Yes.
Senator Washington,
Yes.
Senator McKay,
Yay.
Senator Carter,
Yes.
Chair Smith.
Yes. All right, we'll now move on. So the bill passes unanimously. Senate Bill 115. Senate Bill 115 passes unanimously. Okay, we'll now move on to Senate Bill 150. Council is Shamari.
Senate Bill 150, as written, alters the means by which the state treasurer may send notice of a denial of a claim under the Maryland Tort Claims Act. It authorizes notice to be sent by email, and if the only other available means for notice is regular mail, then the state treasurer may send notice in that manner. After 6 months, if the state treasurer does not send notice, that claim is deemed to be denied.
So they have to like, do they reprint the? So they get it through email, right? And they is an opt-out. Go ahead, Senator.
By certified mail, yes. They're sent by certified mail. They're doing that right now.
Is it still going to be that way in addition to email?
Well, as it's written, they could send it by certified mail if the plaintiff has not opted into the email. But as the statute's written, the other option is by just regular mail, but they're not required to send notice in the first place.
I mean, I just have I have a concern that if we have elderly who aren't as active in their email servers and we're relying that they are, write down an email, that why are we stopping the idea? What's the reason behind stopping certified mail? Because then we're ensured that they sign for a copy of it, that it's been delivered.
It was really a cost saving measure. The fiscal note states that by doing this, they save up to $17,800 per fiscal year. So it really seems like it's cost saving.
Is it an opt? Yeah.
There's concern.
So if they don't respond to the email, then they send a certified letter?
Well, when they're signing up, they don't provide an email. Then it
Then they
still
just
has
get
to
it
be
regular.
mailed and sent.
It's an opt-in.
It's an opt-in.
I understand, but for example, me, I'm an idiot. I don't check my email all the time. I might go days without checking it because everybody seems to send their junk email blast, and I don't see it. Is there a follow-up procedure that requires them, if you don't respond to the email within a certain amount of time, that then they send out a certified letter? Like, it would seem to me that it would be more reasonable that we try everything by email first to save money. However, if they don't respond within 90 days or 30 days or whatever it is, that then we send out a certified letter, because it could be a significant issue that they're facing.
And there's no provision in the bill that allows if they don't receive the email or if there's
Yeah,
no
so that
guarantee
they'll just
receipt of the
lose
email.
their claim.
Potentially, yes.
Can we do an amendment that would assure us that if after they've tried a number of times by way of email and have not gotten a response, that at least there's some
That they follow up with
something that a certified letter, because somewhere making sure that email is not the only way So that we've exhausted all measures, because again, what you said, some of this is very important. People can lose money, they can lose land, they can lose a whole bunch of things. And if they can, and not even know it. So if there's some kind of some kind of amendment that can be drawn up that would include that and put that in the bill to be certain that it's not just by email, but here's a final way of contacting a person, blah, blah, blah. I'd be in favor of the bill.
I can draw.
I think an easy number would be if after 30 days, there's no response after attempts on email, then a certified letter be sent. And then whatever that period is in current regulation now, beyond the delivery of the certified letter, then it becomes forfeited, or the claim is no longer, they're no longer able to defend the claim or be a part of that claim.
I can draw that up. My only, my whole concern is that we're trying to streamline this. You guys are creating another process. And at the end of the day, it's an opt-in. If you don't want something going to your email, don't provide, don't
do it by certified.
do it by mail.
Keep it the regular way it is.
The way it is, it's been going on forever in 3 days.
If you don't opt in for the email,
It's regular,
it's regular mail or certified mail.
correct.
Correct. They'll
And-
choose.
There's two there. It's regular mail. Certified mail.
It's, the way it's written is regular mail if there's no other available means of notifying the
So
plaintiff.
It's not a certified delivery, it's regular mail, so it does change.
No, it functions the way it currently functions. Unless you opt into the email. If you opt into the email, then you get it through email. But if you don't do anything, it functions the way it functions today.
And that's the language, the way the bill is drafted. I understand the confusion because the bill takes out the certified mail
Yeah.
option seemingly, but as written, regular mail is the last option. And so they could presumably still send it out by certified mail if they chose to,
Or they could send it by regular.
or regular mail.
That's my problem. It is, it left open. It doesn't say that it's required to be certified mail. Therefore, you may not be required, then you're leaving someone's claim or their ability to defend their claim in the hands of, did the mail carrier get it to them or not? Certified mail, it's known that they gave it, it's scanned, it's delivered, there's no doubt about it. Regular mail is not as proof positive. I mean, there is stuff that's. And if my kids were to get in my email and open an email and then I don't see it, and then I go down and look through my email and I see it's already opened, I assume, sometimes improperly, that I'm the one that looked at it, but it could have been my daughter who thought it was for some other reason and opened it entirely. I'm just looking at it through a different type of.
Just to be clear, that all this bill does is create an option for you to say, I want to receive this notice through email. That's all it does.
But it actually doesn't, Mr. Chair, it changes it because we send it by certified mail now. This bill allows you to opt in for email. And if email is not done, the follow-up is done by regular mail, not certified mail. So there is a change in the notification. So you can opt in for email, but it doesn't have to be certified mail. It could be a savings because they don't want to pay the $1.30. They only want to pay, bulk mail rate of 35 cents. And we don't have no idea if they got it or not.
So as written now, the law does not require them to send notice by certified mail. That's, as the law is now, it's still just an option to do. And so,
Okay.
essentially, it's just adding the email opt-in option. And yes, the treasurer is not required to send by certified mail if, for example, a claimant doesn't get their email or the email bounces back. There's no provision in that if that happens. But as the law is written and as the bill amends the law, it's just adding the email option.
And so it's regular mail and regular email, or email and regular mail. I would just want to be certain that there's a way that if someone contests and say, I never got it, at least with certified, you've got the receipt, it's coming back. They have it, they know you received it, I signed for it, I received it. Because I've seen messy situations like that in which even our government agencies, which sometimes do not always work efficiently, will say, oh yeah, it was sent. It was sent. They have no way of letting me know when it was sent, how it was sent. And because a person will have a lot at stake with some of these, I feel comfortable if it's not doing anything negative to the bill, to use email, and the final step would be certified mail, so that someone can say, if I don't get the receipt back, I can say, no, you never signed for it. But it's never he said, she said. In that situation with email, it can be, so just amend it to be certified mail and email. With certified mail with last resort.
So actually, under the Tort Claims Act, under current law, a tort claim is defined or denied fully when the treasurer or designee sends the claimant written notice of denial by certified mail. The bill repeals this requirement, authorizes the treasurer or designee to send the claimant written notice of denial by email or regular mail if regular mail is the only available means of notifying the claimant. So my good friend from Hartford County was, with a brilliant research, pointed out that it actually does do exactly what I said, which is the opposite of maybe of the intent, but it says in writing now that it repeals the requirement to do certified mail, which is in the law currently, but we were under the perception that it was not. There was no requirement, but by that, as a part of the bill crafted, says that it's currently required by law. And now we're taking that away and adding email. So this bill does change it.
So I'll look into that and I can draft an amendment and get it to the committee.
Nope. We have one more. All right, so then I'm holding the bill for an amendment. You guys can talk about the amendment. All right, so can Senator Muse and Senator Folden and Senator James get together and just help craft an amendment with Shamari? Is that okay? All right, now we're on to Senate Bill 84. And that is, Shamari, sorry, I'll give you a second to recover. Senate Bill 84.
All right, so Senate Bill 84, as written, requires that single occupancy public restrooms as well as single occupancy restrooms and places of accommodation provide signage that does not imply a gender. So gender inclusive signage. There's not expected to be large fiscal impacts. Presumably entities will have to pay some money to replace signs. And the bill also authorizes individual counties to set fines for failing to comply with the signage requirements. They must give 30 days if they don't comply with the requirement after 30 days. And for a first violation, it's a warning. A second violation is a fine not exceeding $100. For a third violation and subsequent violations, a fine not exceeding $250. There was an amendment that is proposed by the Chairman Smith, to change a technical amendment to change gender inclusive to gender neutral in the bill, and a second amendment to add in a provision that would make clear that the required bathroom fixtures that building owners can count the gender inclusive restrooms toward total bathroom counts for male or female genders as determined by the state building codes and plumbing codes.
There's no real change. I mean, if it says the code says I need to have 20 bathrooms, I'm not necessarily having to pay for 2 more. I can take from the 20 and designate 2 of them as such, right? For the gender, for those restrooms. It's a part of the 20. So it's no fiscal change. It's no hardship on anyone. Is that right? Okay, yeah, sure. Right, because they'll come in and say, oh, we now have to add more bathrooms. No, you really do not. You can do it within the number as set forth by the codes for the building unit. Okay, good. All right.
I have a number of problems with this bill, and I didn't know we were going to vote on it. I'm learning. So I tried to do as much research as I could. So I reached out to my county government, county attorney, local businesses, restaurants, and retailers. And I'm glad we solved the plumbing amendment. But to me, this bill is not only is it a solution in search of a problem, it's really a solution that's creating some problems. Now, the first thing I will tell you is that the language in this bill, I think, is inconsistent. At the federal level, I can write this all out to you all. It's a lot. But at the federal level, we use different language when we deal with bathrooms. And it looks like the same is true in Maryland. And why that's important. So at the federal level and in many parts of the state, you talk about toilet facilities, and then you talk about urinals, and then you talk about water closets. And now, before I get into that, let me tell you why that's important. Someone brought up to me. So if you have a men's bathroom, it's single occupancy, and has what we would consider a water closet. We often call it a toilet, I know, but it's technically a water closet, and a urinal, then you actually have two facilities in that one bathroom. So what this bill might inadvertently do is take all the women's bathrooms and make them unisex, but allow many men's bathrooms to remain as they are because of the language that is imprecise in here. And I'm not beating anybody up, but I really think when you draft it, you should go look at the code and how the language is used. And if I'm wrong, I stand corrected, but this was my research and I feel pretty good about it. So there's already sort of an inadvertent problem. The other thing is, I know that when activists get involved and they come down and you can get 3 or 4 people from a couple of different communities to promote the bill, and then you don't hear any opposition per se, right? It's because, the vast majority of women out there are not following this. But honestly, there's been research out there about women and bathrooms, serious medical and health research, because as I anecdotally mentioned to the vice chairman, I had a problem with this bill for some emotional as well as medical reasons, and have known a multitude of women. But that would be me being sort of anecdotal too, right? So I went out and did a little research, and I recommend to all of you to look up, I'll give it to you later. There's an article very recent from the National Library of Medicine. Why do women not use bathrooms? Women's attitudes and beliefs on restrooms. This was done by the Vanderbilt Medical Center, as well as a Kansas City major hospital. And it's led by women and men who are urologists and psychologists. And for a lot of complicated reasons that I don't think you want me to go over now, but I think you should read it and take a look at this, that women who already suffer from a lot of bladder, incontinence, urinary tract infections, and other things, oftentimes because of the relationship with bathrooms, tend to not want to use them and harm themselves. Because I don't want to get too graphic, but if you're not going to the bathroom regularly, you increase your bladder problems, you increase your urinary tract problems. Other women respond by just dehydrating them. So, I won't drink anything because I can't find a private bathroom that I'm comfortable in. And a lot of women, and this study talks about it, it's an issue of being sanitary and what they worry about, complain about. I'm just going to be honest, never thought I'd be debating an issue about bathrooms, but that men tend to come into facilities, they're less cleanly. They often, if it's just a toilet, they're not neat about it. I'm trying not to get into details, but if you read this article, for women, myself, and I'm going to tell you thousands of the study I'm referring to work with 5,397 women. They take this very seriously. This is a health issue, both emotional and mental. So what this bill does, you call it a signage bill, but it's really an eradication of all private women's bathrooms into unisex, right? And really men's too. And you know what? We should study men. Maybe they have some of the same issues, but women really do have an issue with this. And then my research, again, is not exhaustive and I didn't have that much time, but I didn't see a huge problem or any documented problem of very sympathetic to somebody taking care of their wife, a man taking care of a wife or a caregiver of an opposite sex. I could find nothing that said they are not allowed to go into the bathroom that suits the needs of the person and that they're not allowed in there. I didn't find any research that parents of opposite sex children could not freely go into the bathroom of however it should work. And take care of it and not violate the separation of sex. And honestly, I know of no law in Maryland that prohibits transgender people from using the bathroom of their choice. So to me, you may be creating a lot of issues for women in the state of Maryland. And I don't know, we can go out and take a good look at it, but certainly nobody's consulted them. And then let me just go back to one other thing. I was thinking the sponsor, if this is something important to her county, this should certainly could be a Montgomery County bill. Other counties could take a look at it. You could also, but when you don't have a big imminent problem and you're asking to create a statewide program, you're compelling counties to enforce this, and then you're allowing counties to punish people. I think that unless you've hit a pretty high standard of need, and you can also talk and address the issues for women in bathrooms that is serious, that relates to their health, then I don't think there's a compelling reason or even a very good reason to pass this bill. And I'd certainly like us to think about it and maybe talk about it and think about whether this is something we ought to be doing.
First, I'll just, I'll say, Senator, thank you very much. That was more research on bathrooms that that was well articulated and well researched. I'd say thank you. That's awesome. That's exactly what you want every member of the committee to do this for this type of session. So I'm going to go ahead and did you want Senator Sidner had his light on first, and then we'll go to Senator Muse, and then I've got a plan of action, and then we'll get out of here. All right, Senator Sidner.
Thank you. No, I was just going to be anecdotal. And the senator said that there was nothing that legally prohibits anyone from using the bathroom of their choice. I could imagine if I walked into a woman's bathroom, how I'd be treated. I'm a man who had 3 daughters. And once those daughters got to prior to them getting to a certain age, I had no problem taking them into the men's bathroom to deal with them. After they got to a certain age, I had to say, you know what? I don't feel comfortable, but I need to send you by yourself to that ladies' bathroom because you're of an age where you don't need to be coming in here anymore. This kind of bill helps a number of men who will have daughters and face that issue. I have no problem with this bill, and I intend on voting for it.
I didn't say there was. What I said was that I didn't see a large amount of problem. I didn't say that you didn't have some issues, but not on the magnitude that would require us to do this bill. Sorry, I shouldn't have.
I'm with you. I think I agree with you. I learned more about toilets and bathrooms and water closets than I've ever known. If I may make a suggestion, as you in whatever your the route you want to take is fine. That will maybe hold the bill and let my colleague get to us, if you can, over the next few days, just what's the difference between what, so that we're very clear what we're voting for, and we would take it up in the next voting session with your permission. Maybe that's a route.
No, I think that's right. Look, what I was going to suggest is I honestly don't know how this is going to go, or where this bill's going to go, but I would suggest just adopt the 2 amendments that we have, because it makes the bill better. Sure. And if we can't resolve other issues and people have unreadiness, then we'll just have more debate, but we're going to hold it. All right. So amendments have been moved and seconded. Everyone agrees, and then we'll hold the bill, and we'll carry on and discuss for another day.
Each of us.
No.
Okay.
Yeah, just take your time. Take your time.
You got a week or so, and just.
All right. So with that, that'll conclude our first voting session. Congratulations, JPR.
Hey, first voting session.
2 hours for 11 bills.
The distance clear is all out.